Former President Donald Trump is making a valiant effort to tie up extraordinary direction in Jack Smith's political race obstruction case to the extent that this would be possible. With the High Court's choice last week to renounce Smith's solicitation to jump to the furthest limit of the request interaction, Trump's lawful group is centered around engaging preliminary adjudicator Tanya Chutkan's decision from recently. Trump is particularly quick to reassert his official insusceptibility safeguard that would successfully protect him from any of the charges Smith has brought against him. A large part of the concise testimony Trump's legal counselors recorded on Saturday is a repeat of the unwarranted, established claims that Chutkan killed. However, among those very much trampled contentions, Trump everything except demands that the court decide that the legal executive has no control over anything he did while in office, to administer. As a result, that Chutkan misses the point entirely. He has the heavenly right of rulers, and thusly, no other part of government can contact him. The premise of this genuinely insane declaration is number one of Trump's that the detachment of abilities shields him from any sort of oversight. Before, his claims and protections have zeroed in on the authoritative branch's endeavors to consider him answerable or, specifically, asserting that the equity division can't penetrate chief honor, in spite of both the president and DOJ being important for the presidential branch. This time around, there's an original spotlight on the scope of the legal executive itself to police the activities of the president. Under the doctrine of separated powers, neither a federal nor a state prosecutor, nor a state or federal court, may sit in judgment over a president's official acts, which are vested in the presidency alone, his lawyers write in their brief. They emphasize that a president's official acts aren't examinable by the judicial branch, a principle that dates back to the landmark 1803 Supreme Court case Marbury v. Madison. Trump also contends that senior officials, like, for example, the president, shouldn't face criminal charges from a possibly hostile judiciary. Both of those arguments are based on a set of very, very tenuous assumptions. First, the idea that the judicial branch can't touch him at all hinges precariously on the phrase official acts. It's a broad phrase that, generally speaking, refers to actions taken by the president that involve enforcing duly passed laws. If President Joe Biden issues a policy related to the climate change provisions in the Inflation Reduction Act, for example, that's an official act that can't be the basis for civil or criminal charges against him. For that to apply here, it would require that acts taken by Trump after the 2020 election were all official acts sanctioned under duly passed laws. In this version of reality, rather than trying to retain power despite losing the election, Trump was merely rooting out fraud and ensuring that election laws were properly applied. It's a claim we've heard elsewhere lately, as Trump has attempted to stay on the ballot and to deny that he was engaging in an insurrection ahead of the January 6, 2021, attack on the Capitol. Neither Congress, nor the courts, nor the voters themselves can constrain a president in his framing. As Smith's indictment makes clear, though, that is not at all the case. Instead, Trump pursued unlawful means of discounting legitimate votes and subverting the election results, and in doing so, he targeted a bedrock function of the United States federal government, the nation's process of collecting, counting, and certifying the results of the presidential election. Like actions taken after accepting a bribe, there is nothing official about acts that proceed from illegal activity. Trump's rejection of judicial authority also assumes that there's a transitive property to what's known as the Speech and Debate Clause. In short, Article 1, Section 6, of the Constitution provides that a member of Congress can't be arrested for any speech or debate in either house. It's meant to be a protection against a rogue executive punishing legislators for making an argument while debating a draft law. You'll note that there's no section of the Constitution that says anything similar about the president, or former presidents, for that matter. Moreover, a senator railing against a bill isn't at all similar to what Trump was up to after the 2020 election, no matter how much he tries to insist it was merely protected political speech. In citing cases involving legislative immunity and judicial immunity, which supposes that judges can't be charged for legitimate actions taken from the bench, his lawyers are attempting to create an equivalent prerogative for the presidency out of whole cloth. The closest they come is in citing a Supreme Court case in which a civil suit against former President Richard Nixon was thrown out. But again, those examples all rely on the actions in question being legitimate and not part of a self-serving conspiracy against the country. It's true that there must be guardrails to allow for the independence of the three branches of our federal government to operate without undue interference from the others. But when you look at not just this one appeal, but the aggregate constitutional worldview Trump has espoused over the last 7 years, it's obvious that guardrails are not what he's advocating. Neither Congress, nor the courts, nor the voters themselves can constrain a president in his framing. For the courts to agree would make Trump a president in name, an emperor in practice, and nothing close to what the Constitution and its drafters intended. Hayes Brown.